Good morning, everybody. We start with the subject immediately. Documents consist of all papers related to patient's treatment. So, your OPD paper, your investigation paper, indoor paper, consent, operation notes, discharge card, everything includes documents. Addition would be your registers in hospital, because they are also equally important. We have generally operation registers are there, sterilization register is there, fumigation register is there. So these, and even your OPD register, indoor register, they are the part of your documents because they may be required in the court. So this includes all documents. Few seconds for explaining the importance of document, because the title is very interesting, friend or foe. So I will start with a small example. A child goes to a pediatrician at 6 o'clock in the evening for complaints of loose motion, dehydration, or clinically. A semi-urban hospital, doctor stays upstairs, hospital is below. Pediatrician sees the baby at 6 o'clock, then again sees puts in on salines at 9 o'clock, 12 o'clock at night, 3 o'clock in the morning, sends investigations, sends blood for grouping matching, he thinks so, it may be required. And at 7 o'clock in the morning, when he is having tea in his house, gets a call from hospital below, baby is serious, by the time he comes, baby dies. Now, the further part is covered legally as it should be, but after 6 months or so, the doctor is charged with negligence. Patient relatives alleging that we went to the hospital, doctor saw us and never turned up at night. Nothing was done, just IV was started, nurse was changing IV bottles. And in morning, baby was very serious. Doctor didn't come early. When he came, the baby died. This is a story in the complaint. Whereas doctor says that I saw the baby at 6 o'clock, 9 o'clock, 12 o'clock, 4 o'clock. I have done investigations. I have sent blood for grouping matching. So I have done what I could have done. Now, when the case goes to the court, maybe after 2 years for discussion, tell me how a judge will decide between these two sets of complaint and defense. The only answer is your document, because what has been written on paper, whether doctor saw the patient on 3 o'clock, 6 o'clock, 9 o'clock is immaterial. Whether it has been written on the paper, what has been written on the paper, what were the findings, what was done, and has it been documented. If he says investigations were done, at least the investigations report have come or not. Blood, if you say blood was sent for examination, at least there is a confirmation from the blood bank that we have received the blood sample, etc. So all these things will have to be discussed. If there is a failure, I am not saying whether in seeing the patient or whether there is a failure in writing, it becomes, your notes become your enemy. And if you have written good notes, naturally they are your friends. In fact, even if you have not seen the patient and written the notes, still for the court they are your friends. Now I will cover some important aspects of documentation. Namely, they are consent, certificates, discharge cards, because these all are important in our writing. Then referral notes, prescriptions, etc. Consent I will make only short points, because the sessions given are here are basically for the law students, because they are covered in the Contract Act. But for general medical population, we do need not go through the sessions. We can anytime refer in the book. It should be consent from the competent patient. That means a major person. If it is less than, it's not adult, it should be represented by the guardian. Especially children in hostels around 15 years, if they are needed for operation, I mean rector is the guardian. For a valid consent, I have already told you, competent person should be, he should be in a sane mind. Major. Child between 7 to 12 years is a little grey area. Above 12 years, we advise that there should be a consent from the child also. This is a little new, but because many people don't follow it, but there is a clear-cut court judgment in UK where this was followed, that the child's consent after 12 to 18 was accepted over the negative consent by the relatives. So we should take consent if it is above 12. It should be accompanied by 2 witnesses consent. Consent should be in simple language. It should be operation specific. The last days of any operation by anybody, anytime, these were the consents 25 years back. Now we don't take consents like that. We are very specific what you are doing. Then mention the common complications. The incidence of complication as per the decision given by Supreme Court is any complication which is documented, book referred, if it is more than 10%, it must be mentioned. If it is less, generally there are very few complications which is more than 10%, sir would agree with me. Gross complications we should say. So in short, though hernia complication rate is 2 to 5% recurrence, but I suggest that you mention this complication in your consent. For sterilization and castration, the both spouse consent should be there. As per the MTP Act, only mother's consent is adequate, but we suggest that consent of both should be there, or at least mother should write, the lady should write that it's my responsibility to, because husband may not be there. Husband is in Dubai and she is getting operated. So there should be a clear-cut writing in the consent that it's my duty to inform my husband. Why this legally not needed? Because otherwise you have to face family court. In 1 year they go to the court for divorce or something, and the doctor is called as a witness, and doctor has to go 10 times to the court for no reason. So if you are an operating surgeon, I would say that forget about the law, you insist on consent of both. For amputation, technically appendicitis is amputation, even tonsillectomy is amputation, but for these you may not take consent. But when you are salvaging a limb, especially not a small finger or something, especially a bigger limb, hand, leg, you must take another opinion concurring for the amputation. Consent should be written. Implied consent is also accepted. Previously dentists never used to take consent, because going to the dentist, opening your mouth and allowing him to remove your tooth is itself a consent. But nowadays cases have come to light that wrong tooth was removed. This was an allegation in Pune. We had to go and help the doctor in police chowki. So it's better that you take a consent in writing as far as possible. Informed consent, I have already told you, relatives should be informed about the complication, seriousness, everything should be informed. Significant material risk should be explained. Another thing, the alternative modality also should be explained to the patient and taken in writing to that effect. Now important part is refusal of consent. Standard tactics of delaying the consent. सासूबाई यायच्या आहेत, नणन यायचे, सीझर जरा वेळाने त्या आल्यावर करू. Forget about this. If you think you need an operation, you insist, you write on paper that they are not giving consent. Tell them that they are not giving, you have to give consent because I am asking operation as urgent operation. Otherwise, at least write on the paper that the consent was denied. There is a clear case where the burst appendix, because there was a delay for operation and it was delayed for about 30 hours, and then the defense taken by the doctor, there was not, that the consent is not given. The court has given a ruling that this is not allowed because doctor has not written anything on the paper. This is an afterthought. That was the court's logic. Truth, we do not know, as I told you in the beginning, what is documented is the final. So in short, doctor should not feel shy of informing and taking a refusal to that effect. Boldly document the non-compliance of your advice. I will skip the cases. There are n number of cases in regarding the consent. For the short of time, I will skip. Thyroid adenoma, even non-consented removal of adenoma was pardoned once upon a time by our courts. But now we should take consent very meticulously. Samira Kohli's case just now madam has discussed. Don't exceed, which has not been written in the... So in short, the case endometriosis was diagnosed, operated, and hysterectomy was done. And then ultimately the court said if it was not urgent, you should not do any operation which is not consented to. You must restrict to the operation only. Coming to certificates, certificates should be on letter pad. Our register number has to be there on certificate. It's like a shop act number which is printed on the bill of a receipt. Bill or receipt, they print shop act number. We should write our register number. It should be your qualification address has to be there. Mention date, time, and place of the issue. There is the best friend in certificate is a carbon paper. You should have a copy of your certificate with you, so you know what you have written and what has been documented. There has to be an identification mark, preferably now I suggest thumb impression. It has to be there on the certificate, because nowadays even in courts they have started taking thumb impression photo identification. Especially in whole case paper. I will come to a case paper at that time. I will explain. Just now I am explaining. Somewhere in your hospital record, there has to be patient's identification and thumb impression, as well as write what has been used as a photo identification of the person. It should be. Nowadays Aadhaar card is very common. So you can write on the paper the Aadhaar card number so and so, the person identification has been confirmed. So this becomes very useful. There is a case where one brother got admitted in Bombay, in big hospital in Bombay, sir, admitted for renal colic. He painted a picture of severe pain, got Baralagan at that time, relieved, got discharged next day morning, got certificate from yesterday 3 p.m. to 8 a.m. next morning for renal colic. And his brother committed a crime. The name was same given here in hospital name, and at Nagpur whatever the offense was made, same name. Ultimately, luckily it struck to one of my friend that yes, hospital register has got an identification while they get admission in CMO, and that was verified for the certificate, and ultimately the offense was proved.
Dr. Sanke, I can name because he has allowed me to do so. Pathology. None of the pathologists used to take the identification of patient.
Now they have started, I think.
One patient from Behere, because of my case, one patient from Behere came and he was suffering from AIDS. So he gave a positive report. That patient's name was something else, and the person whose name was given, that patient had no AIDS. He went to all the hospitals, got the reports and filed the case.
Sir, leave aside, in Wadia hospital, I am naming the hospital in Pune, the patient gave, it's another hardly 50 yards away from my hospital. The patient got admitted for reimbursement sake. The name of the brother was given, and by his ill luck the patient died. And then the relative started saying, "Hanawa's certificate nahi, amala, we want this name." Because by that time the death name was more important rather than the reimbursement. And then we had a hell of a problem. We had to inform police, take a affidavit from them stating that these facts have been done inadvertently. We told them that you write it inadvertently. For us, we will be sticking to the rules.
Also, pathologists still are not taking this.
So in short, I think audience has realized that what is the importance of identification.
The problem is that the major problem in HIV patients you talked about.
Yeah.
If the patient is positive, the patients are not giving the real name. They are giving something and they don't want to.
That's why the use of photo identification on your case
It's a
paper.
very good point which has been.
Yeah.
I mean,
No, I faced that case and we had a tough time. And he said, I am.
Sir, I get so
lose the
many
loss.
investigations which are by other name and they just don't want to disclose. So they want none of their relatives or friends to.
Most of the time after diagnosing.
There is also a fallacy in the existing rules. Which
Okay, sir, we will discuss afterwards. Let me finish the lecture.
I think this point will take
Yeah. For death certificate, you shouldn't take any fee. That's what the medical council has guideline. Many times you are called in the night for confirming the death at house. You can charge the house visit, but don't charge for death certificate. Confirm death personally. Don't give blindly. 3 hours back I have seen the patient, now he has died. No, don't have a faith on his narration. Confirm yourself and give. Suspected homicide, of course you have to inform police. Get acquainted. I mean, there are new format of certificate now. It is 10 years old. Everybody knows that. For will document, again, photo identification is extremely important because you should write that you have identified the patient. Because one old lady is painted as some other name and the documentation is made as a will, and that is unnecessarily used in the court. We had to face difficulty in proving the identity. So photo identification in will document, especially when there is a property, charge high if the property is high. Don't worry. I mean, invariably more the property you are likely to go to the court. For indoor paper, it should be clean, avoid overwriting. It has to be correct, chronologically correct, especially small hospitals, anesthetist goes away for other case. The notes are written after 2 days and in between there are post-operative notes and by the surgeon. This shouldn't happen. Keep a separate case paper, operation notes and anesthesia sheet. It should be attached to the paper. So this point of chronologically going wrong, because unnecessarily you have to face the music in the court in front of opposite lawyer. How much time medical documents should be preserved? This is a very common query. All medical legal documents, 30 years preferably forever. Registers, OPD register or the registers I mentioned, they should be administrative paper for 10 years, indoor for 5 years. Medical council case says 3 years, but we suggest 5 years because case can go afterwards in the court. OPD paper for 3 years. Identification mark has been already explained. This is a reference if anybody wants to shoot. Director General of Health Service by its circulator, they have given these guidelines, so I stick to these guidelines for, it should be with you for your reference. Whose property? This is a common question. Hospital paper, basically a hospital has a right of keeping the papers, but when patient demands, you have to give a copy. In court's verdict, the copy should be given in a reasonable time with reasonable fees. Because I have seen a hospital for giving 10 pages case paper charging 5,000. And in short, it is a way of saying that I don't want to give you a case paper. Don't do that. It will land you in the court. So give a copy. Take precaution while writing the notes, which is more important. Of course, if somebody is asking a case paper copy, be doubly sure that you have written everything, you are not inadvertently omitted. You take more precaution in seeing the case paper before handing over. Patient has a right on demand and do not say no. Discharge card is extremely important. Generally, there is a negligence on doctor's part while writing a discharge card. There is a case from Himachal against Himachal Pradesh government. Bilateral tubectomy was posted for surgery. One tube surgeon couldn't find. He had documented it in his notes that right side tube could not be found and to be explained to the patient. But he forgot. Houseman while discharged wrote bilateral tubectomy. Patient came after 1 month with pregnancy. OPD houseman was different. Bilateral tubectomy. It's not correct. Come after 1 month. Next time some other houseman. Come after 1 month. By the time 3 months passed, the time for MTP had gone. Then they say, oh, unfortunately you are pregnant. Nobody saw the case paper. Unfortunately you are pregnant, this can happen, tubectomy can fail, now you go for a child. That was the 7th or 8th daughter to the patient. She sued the hospital for wrong thing, not tubectomy failure. There was a hue and cry in gynecologists at that time that tubectomy can fail. If you read the court judgment carefully, court has clearly written that this punishment is not for failure of tubectomy. We are very well aware that tubectomy can fail. It's for wrong notes. So notes are very important. Especially senior surgeons, when a houseman is writing notes, teach him all right. Otherwise, check the surprise check should be there for discharge cards. Summarily, discharge card should cover all the important points. Coming to prescription, as far as possible, prescription should be a neat, good doctor's handwriting. Drug should be in capital letter. Strength of medicine has to be written. Write a correct dose, frequency of taking interest. The interesting study is, this is a case where a Calcutta, interesting doctor from Calcutta studied and some 2000 and odd prescriptions, and the result is very important. Only 44.67% of patients could tell the correct dosage of their drug. So that was his conclusion. In short, we doctors don't take pains to explain the dose and frequency of the drug. Referral notes are extremely important. Here again the carbon copy should be there. Carbon paper is your best friend in writing your notes. Because this is my personal experience. A patient of head injury was admitted. I saw it Sunday morning 9 o'clock. One pupil dilated. I gave a chit to one nursing home, a big Ruby Hall in Pune, because CAT scan was available only there at that time. I ordered CAT scan and told them, wrote that you deal with the patient. Luckily, I had taken acknowledgement from the mother that we have received the referral chit to Ruby Hall Hospital on carbon copy of mine. I had taken the signature and time, date and time. And they didn't go to Ruby Hospital because by the time they went home, the baby was conscious. And so they preferred to wait. In the evening, baby became unconscious, rushed to hospital, CT scan, bore hole, baby died. And I got a notice for not sending the patient in time. At that time, my carbon paper copy saved me, which clearly mentioned the referral date, time, reason, all things. So just as Xerox copy of carbon paper was adequate to save me the case. Certificate should be given by a person who examines. This slide is newly made, that's why I am not very conversant. It is specially made for the Sancheti hospital, sir, because you get many medico-legal cases, injuries and all that. So I prefer to make this slide because there is a controversy at many places who should go to the court and all that. As per the requirement, one who sees the patient should go should write notes and police certificate. All accidental cases should be informed to the police. That goes without saying. One who sees first should write notes and issue a certificate. And the important point is hospital should have a policy of keeping addresses of all housemen, even if they leave the service. Because the case goes to the court after many years and it becomes extremely difficult to trace the houseman. So nurses and housemen, when they leave, let hospital should have a register of their new addresses. Politely, you can leave, but give us the address because in court you need it. There are tricky, I mean there is a very interesting case. Patient was admitted for a blood injury abdomen, police case was made. After 7 days, they found a huge hematoma along with liver. And the problem came, who should certify? Can CMO certify or the indoor physician who ultimately at the time of discharge diagnosed hematoma without intervention, patient went home. So the admission was not for more than 7 days. So whether it is a grievous injury and all that, so all that dialogue has come in the description of the case. The summary is first doctor, and in some rare cases, the in-charge doctor must certify. That is the inference. Court has given a guideline. Summarily, write advice on investigations only, because we have seen patients, if you write investigation below the prescription, they cut that lower half and then say that investigations were not advised. So write investigation somewhere after the name and then write your prescription. That is a correct method. Always give next appointment, so that on your side, especially which is important for plaster and cases, there should be a standard policy of care of plaster somewhere displayed in the hospital, so that care of plaster is automatically construed as you have narrated to the patient. So especially for orthopedic patient, care of plaster has to be explained. For dental people, we suggest that post-operative care after removal of tooth should be displayed. So it's a good habit to display the instructions. Preferably, if you are giving a discharge card, write the notes, because invariably non-union of fracture, patient walks in plaster and says, I was not told about the rest and all that. Yes, 1 minute only for me. Don't become diffident, but be careful, confident and considerate. Update your knowledge. The simplest thing is treat your patient as your father, mother, brother, like that. Then you are less likely to commit mistakes. But my saying is, don't stop at this compassionate treatment, put it in writing. That is more important. These are the 3 important cases. If you like, you can have a photograph of it, because these cases would help you in case of emergencies where the courts have given landmark judgments, where the criminal case there is a clear-cut Jacob Martin judgment which states that the expert opinion should be taken. Then Maharashtra Prevention of Violence Act is also very important. So these should be there for your documentation as a standard policy in the hospital. I think I have tried to finish it a little hurriedly with a short of time, but anything query we will tackle later. Thank you.